My name is Roland Demers. I'm with Blackhawk Security and Safety Consultants out of Treasure Coast, Florida, Port St. Lucie, Florida, to be more precise.
Hello, my name is Jeff. This is 2A Self-Defense Law. What we do is we help people understand the law of self-defense in the simplest terms possible. We take the fear out of getting it wrong.
And we're here today with some former law enforcement, former military from the States, and former military from overseas.
Today we're going to be correcting a video that has gone astray. We've gone over this several times before about castle doctrine, duty to retreat, stand your ground, what it is and what it isn't. Right now this video is what it isn't, or is, or what it should be. Okay, this gentleman does seem like he wants to get the right information to you. However, it's not quite correct. And what we'll do is we will tighten it up for you and tell you exactly what the errors are.
And some civilians that are entering the Tier 2 law enforcement arena here in Florida. And we are going to address stand your ground and castle doctrine locally as it applies to the state of Florida. And we'll speak a little bit about issues that you've had in other states. The one thing I'd like to start off by saying is at the present moment, statistically, we have 35 states in the United States that have stand your ground or a interpretation of the stand your ground rules of engagement if you have to defend yourself.
I'm not going to bust his chops on this one. There are currently 37 stand your ground states, and a couple more should pop up next year. So it changes every single time.
We have 15 states that are duty to retreat states. And ironically, the map that reflects the duty to retreat states, I will say all match in the color blue.
I want to stop it right there. You can understand what duty to retreat is by his expression. He thinks it goes upon his machismo, his manhood, to actually have a duty to retreat. He does speak about it later on in the video that I will not be playing, that he does recommend seeking all alternatives before you engage an individual in a deadly physical fight. So we will discuss what duty to retreat actually is a little bit later.
That being said, stand your ground essentially is an understanding. I'm not going to say it's a statute because it changes from state to state. So it's not a statute in the state of Florida that's called stand your ground. Stand your ground relates to an understanding. The constituents voted here in Florida and it was applied. And therefore, if you're in a position where you have to defend yourself, you are not required to stand your ground. By that, the state of Florida does not say, get up and start shooting at people that threaten you or start an argument with you in a parking lot. Rather, you have to be in a position where you truly believe that your life is at risk and you're about to potentially lose your life. You are in fear of your life and therefore feel the need to threaten with or apply deadly force.
The information that he has given you about stand your ground is simply not true. That you have zero consideration of a duty to retreat in the state of Florida. Listen, people, you in the state of Florida and most of the states in the nation, especially with the stand your ground verbiage that is in black and white in a statute, you have two obligations before you can have a duty to retreat: that you are legally allowed to be where you are and you're not committing a crime. And let me tell you how this is so. Let's just say you and your significant other was at a late dinner, and now you're going to go to the other side of the park and watch a movie. So you and your significant other is walking through the park. It's nighttime, and someone comes up to you with a knife and says, "Give you all my money." Do you have a duty to retreat? Yes, you do. Because in that city, that park closes at sundown. So you are not legally in a place that you are allowed to be. So you have to have a retreat consideration. Now, for you guys who believe that you have no duty to retreat because you're in a duty to retreat state, let's look at Pennsylvania. Okay, Pennsylvania adds a third option. for you to consider before you have a duty, before you can stand your ground. Again, it's always you're in a place that you're legally allowed to be. You're not committing a crime. And look right here, the person against whom the force is used displays the otherwise use a firearm or a replica or any weapon readily or apparently capable of lethal use. Okay, these are the hoops that you have to jump through, especially if your state has a black letter statute itemizing exactly what you do. Now, for you people who are in a stand your ground state that uses case law, well, it's much different.
Stand your ground also is interpreted in another manner and cited as castle doctrine. The castle doctrine essentially has evolved to protect a shooter who is in defense of himself or herself in their primary residence, in their residence or the confines of their vehicle. That being that if anything occurs within the vehicle, doors closed, music in the background, AC's on, you're in the confines and something happens, it's going to be a castle doctrine case if you find yourself a defendant because the outcomes of the shooting is not in your favor at the moment.
I want to be extraordinarily clear in this. Stand your ground and the castle doctrine are two different doctrines. All stand your ground does is remove an existing duty to retreat. We've already taught you that. Every state, especially the states that have the duty to retreat with a black letter law, is usually going to say you have two hoops to jump through. We've gone through them, all right? That's all it does. So that's why you have an existing duty to retreat until you jump through those two hoops. Then you have a stand your ground, okay? Castle doctrine. This is one of the reasons why I rarely teach specific castle doctrine, because it's literally 50 states over the past 250 years developing a castle doctrine to suit its needs in every 50 states with every appellate court decision. Okay? They are completely different. What the castle doctrine does do is give you a presumption of either innocence, eminence, proportionality, avoidance, and reasonableness, depending on the state and depending on the situation. All right? Do not use these doctrines as a roadmap on how to do a physical fight. You must win the physical fight, but you have to know innocence, eminence, proportionality, avoidance, and reasonableness. These laws aren't tactical doctrine. It's not made for you to think about it and then react, because you will not know how to react with every different situation. We're going to be talking about New Jersey, and that uses the model penal code, which is an absolute disaster because it has so many different scenarios and you can't follow the flow chart. How are you going to follow the flow chart for a castle doctrine for New Jersey? You're not. So basically you need to prepare for innocence, eminence, proportionality, avoidance, and reasonableness for the physical fight. And if you go to court, use the castle doctrine and stand your ground as an added insurance.
Outside of that, in the state of Florida, stand your ground applies to every last square foot in the state of Florida that is not your primary residence or the confines of your vehicle. Now, with regards to castle doctrine, interestingly enough, there are some scenarios that may qualify a shooting to be castle doctrine. A good example would be is you take your relatives, your family members to Disney, and you decide to rent a hotel. And you end up being the victim of a robbery inside your hotel. The doors are closed. You've checked in. Your family's there, luggage on the bed. And you end up involved in a shooting where you've had to defend yourself from somebody who may have breached your hotel room. In that particular case, chances are that your defense attorney is going to cite castle doctrine. The reason being is that's where you were laying your head that night. That was your domicile for the evening. So there are many different ways and factors in which somebody would conclude whether you are going to cite stand your ground or castle doctrine.
As I stated before, do not go into the physical fight trying to figure out that if you're going to be using stand your ground or castle fight for the fight in the courtroom. It doesn't make any sense to do so. and he was talking a little bit about curtilage. Curtilage is going to be anything outside your home. And again, curtilage is something that has been defined by 50 states over the past 250 years, and what is curtilage in one state is not curtilage in the other. Specifically, Massachusetts, is if anything is outside the four corners of your home, is going to be is not going to be protected. Some other states, a well-worn path to an outlying garage, it's going to be protected. But again, you do not get into these situations saying, "Oh yeah, I have curtilage, so I don't have to, so I can stand my ground and I can be here like a stubborn mule." If you can get away, get away. Avoiding the physical fight will always be the top priority, and it's not going to look bad on your manhood. And again, he is correct. Hotel rooms, campsites, RVs, places where you lay your head, you will have added protections, but those are presumptive protections, and that is for the fight in the courtroom. The one thing I will say is that if a robber does go into your hotel room and is clearly robbing you, Florida has an itemized violent felony list of violent felonies, to be repetitive, that you can use deadly force. Okay? So let your lawyer decide if they're going to use a self-defense of the castle doctrine to protect you, or case law in Florida where violent felonies, you can use deadly force.
Duty to retreat. Now that's a major challenge. And if you live in a state where duty to retreat is the rules of procedure when deciding to engage or not, and in defense of yourself or your loved ones or somebody else, you are required to make every attempt to retreat, to separate yourself from the threat. And one particular case that I do cite quite a bit, we have a lady, a single lady who lived in a 2-story condominium in New Jersey. Her master bedroom was on the second floor. She had a balcony on the second floor, just outside of her bedroom. We had sliding glass doors leading to a small balcony. About 3 o'clock in the morning, she had a burglary. Person broke into her property, proceeded to go from the first floor up the staircase to her bedroom. She armed herself, tucked herself in a corner by the night table. The person broke into the room and she shot him twice. The outcome to that was that the lady found herself being charged and became a defendant in a criminal case, ultimately in a civil case as well. And what occurred there was that the prosecutor showed her a series of images, and these images were relating to her bedroom. And the prosecutor asked if there were sliding glass doors behind her bed, and she said yes. And he asked, could you have made it to the sliding glass doors at that time? And she said, I could have. And she said, if you jumped off the balcony, would you have died? And the lady said, probably not died, but I would have broken a leg. And that's essentially all it took for her to be found guilty in the state of New Jersey.
All right, there's a lot to unpack here, so let's get through it. On the photo here is a guy of St. Thomas Aquinas. Okay, he wrote a lot about the duty to retreat because he was a philosopher and he was just doing his thing, and then the king picked it up, and the king wanted no one else to be able to defend themselves, basically, that he didn't want anybody to kill any one of his subjects, so you basically had to ask the king to defend yourself before you could defend yourself. And so that was part of common law, and then the United States picked it up. And as it was put into play, what happened was there was something called an affirmative defense. What affirmative defense was, that it was the defense's obligation to have the burden of proof and the burden of persuasion for a self-defense event. The burden of proof is that you had to prove with more than zero evidence that there was a self-defense event, and you had the burden of persuasion of the finder of fact that it was. Okay. Now, over a period of time, it morphed a little bit, where it no longer is an affirmative defense, Now, some jurisdictions may still call it affirmative defense because they changed the definition of what affirmative defense was. But self-defense is in general no longer an affirmative defense. You still have the burden of proof. In every jurisdiction, you have to have at least more than zero evidence that it was self-defense. Okay? Now what has happened is that the burden of persuasion is on the state to prove beyond a reasonable doubt that it was not self-defense. So it's no longer an affirmative defense. Now, after that period, in the 60s and the 70s, it changed a little bit. The prosecution started going after the weakest link of self-defense: innocence, eminence, proportionality, avoidance, and reasonableness. What is the most subjective one? That is duty to retreat. Okay? How can you prove that you couldn't do something? You can't. So what started happening was that people who were defending themselves became a political issue, political football, and the state started using it as a political football. And that's where duty to retreat modified into stand your ground. I'll be talking a little bit more about stand your ground later, and you'll be shocked who is the original stand your ground state. Listen, I'm not in a big fan of stand your ground because it is so subjective, and it puts you in a bind between safety or not. But you have to realize, and this is true for any duty to retreat or any state that has a position that you need to, or you have a duty to retreat. Hey, you people in Florida, you have a duty to retreat. There's one scenario in your home that you still have a duty to retreat, is that you have an invited guest in your home, or you invited a contractor in your home and something goes wrong. You have a duty to retreat until you give a trespass notice. All right. So you can't blindly say, "Oh, I'm in a duty to retreat state. I can stand here like a stubborn mule and just act like a total jackhole." It's not true. You need to, if you already, listen, duty to retreat is quick, immediate. You will know if you immediately can get out of the scenario or not. And again, this guy totally talks. Later in the video, that's not going to be played here, that if you have an option or to retreat, you should do it. Duty to retreat states are not going to require you to turn your back and get stabbed in the back. It's not going to happen that way. And in fact, in most incidences, you have less hoops to jump through the duty to retreat, because if you can immediately and safely, and I'll give you case law here shortly, that's what the verbiage is, no matter what state you're in, that the law isn't going to make you egress into a raging river. All right, it's not going to. Let's get into this the New Jersey thing also. We'll start off with it. I don't know what case that is. I've heard several stories of what if scenarios that people get off the internet. All right, I will guarantee you this. All right, it sounded like she went on the stand and something happened. I don't know what the specifics is, but in all 50 states, the verbiage is clear. If you can safely remove yourself from an incident, you're required to do so. It's not going to make you jump from a second-story building. The law is not going to make you run into a highway and get hit by a car. Okay? It's not going to do that. So the characterizations that you have to egress your house and put your life in more jeopardy, like a perfect situation here in Minnesota. It's 60 below out, and someone breaks into your home. And let's also, I'm not going to pull that up also. One of the key specifics into duty to retreat inside your home is that a door is broken in from, okay? That assumes that the bad guy is there to do harm, okay? That also gives you a reasonableness a bent on things. So people are going to think that you're innocent. Okay, you're the innocent party because you're inside. Your actions are going to be reasonable, and other states are going to give you even more. I'm going to be doing this case law, and the reason I'm just doing this case is because it's in Minnesota. It's the easiest for me to get, okay? And Minnesota is going to be a little bit different than New Jersey because Minnesota, in case law, has said that they have no duty to retreat inside the home. So let's just go through this. A person is outside his or her home. Don't get into this. I will guarantee that most of the case law, if not all in all 50 states, will say something to this effect. Can safely retreat, then the person's use of force is unreasonable as a matter of law. Okay, the thing is safely retreat. It's not going to make you jump off a building. It's not going to make you jump into a tank of sharks. It's not going to make you eat scorpions and get poisoned. It's not going to increase your jeopardy. So when they use this New Jersey case that nobody states, nobody has ever found. He says he cites it, but he doesn't really cite it. It's not true. And to say that the jury convicted her because she wasn't willing to jump out a second-story window, I wouldn't put it past a jury. They're a bunch of broccoli stalks in the end. You never know what they're going to say, but that's not what the law is. I guess I will get into a little bit because it is a statute, and for New Jersey, and I'll just get over it real quick. Section 2C 3 and 4. Subsection B. The actor knows that he can avoid the necessity of using such force with complete safety. Okay? It's always going to be there. Whether it's going to be in case law or the black letter law. It's always going to be there. If you can remove yourself in complete safety, that this is not a bravado thing. This is not because someone is disrespecting me. If you can leave, you should leave in complete safety. Talk about a little bit about AOJ. The best thing to see if you can leave in complete safety is the AOJ triad. Okay, does the perpetrator have the ability, opportunity, and jeopardy to attack you? The ability is, do they have a deadly weapon, or can they, or what are they doing? Have the ability, the opportunity. Are they close enough to implement that tool? And jeopardy, that they have shown some physical aggression using words saying that they're going to kill you, or their intent is clear. Okay, we talk a little bit about the Tueler drill. Okay, it's not a Tueler rule. It's not a 21-foot rule. It is your subjective way on what is happening. Remember, the Tueler drill was designed for police officers, open carry, where they can get their gun out of their holster and put a shot down range. Okay, we all know that in 1.5 seconds, the bad guy will go 21 feet. But for you specifically, let's just say you were a woman and your handgun was in your purse. How long is it going to take you to get the purse, draw your weapon, and fire? So that 21-foot rule could be lower. It could be higher. Depends on your age, your ability. So the Tueler drill is for you specifically.
I was trying to research to find out. I believe that the state of Florida is the brainchild of Stand Your Ground. I couldn't find the information to know if there was another state that implemented it first or enforced it or encouraged it. I know that the state of Florida is known throughout the states as the most aggressive supporter of Stand Your Ground.
Well, I hate to burst his bubble. Florida wasn't the brainchild, and this is something I'm not busting his ass on. It's just something that he didn't know, or he just didn't know how to look up, and that is fine. The original Stand Your Ground state is the biggest blue state from the late 1800s, early 1900s. It's the state of California, and the law. It's so old. The last one I remember offhand, and I'm not going to look it up because this is getting too long, is Beard versus United States. And if I remember right, it was about a gambling debt, and the prize was a cow. Okay. So California is the original stand your ground state, and here it is. In again, it's so old that it's just put into his jury instructions, and it's the easiest thing to look up. Calcrim 505, and here it is. A defendant is not required to retreat. He or she is entitled to stand his or her ground and defend himself or herself, and is, if reasonably necessary, to pursue an assailant until the danger of death or great bodily harm has passed. This is so even if safely could have been achieved by retreating. So California and Texas is one of the few states where you can pursue the aggressor. I wouldn't recommend it, but because it could get you into trouble afterwards. But once the threat has ended, I would recommend stopping, because just because it's legal doesn't mean that you should do it. It should be an added protection to do it. And the other thing I want to talk about is there's a lawyer out there called Andrew Branca, and he's come up with a term of hard stand your ground states and soft stand your ground states. Utah was my example, but they have changed over to a hard stand your ground states. And I may be wrong about this, but I think Kansas is a soft stand your ground state, where if the finder of fact thinks that you were so unreasonable about your stand your ground that you had an ample opportunity to get away and your ego got in your way, the finder of fact could find you guilty of murder, even in the stand your ground state, if you chose to stand there like a stubborn mule and mule a lot. Now, what a hard stand your ground state is, and it's listed here right in this Calcrim 505, the last sentence. This is so even if safely could have been achieved by retreating. The reason they put that in there is then the jury has the finder of fact cannot consider reasonableness as part of a duty to retreat. So, not the brainchild. Florida is not the brainchild.
Shameless plug. If you're somebody who is into the duty to retreat lifestyle, I ask you to change your driver's license and zip code. Come election time, you could head north or head west or head east until you can't head no more, because we want to keep it stand your ground. We want to support law-abiding gun citizens. That's what Stand Your Ground and the Castle Doctrine are all about. It's about supporting law-abiding citizens, period, and giving them the right to live a life and not to be in fear.
Again, I just disagree with his characterization of duty to retreat. Yeah, duty to retreat is mainly for anti-gunners who doesn't really know what duty to retreat actually means. Again, in his own video, and I'm not going to be playing it here, I've talked about it previous, he recommends duty to retreat. Okay, if you completely can get out of there in complete safety, you should do so. You should absolutely do so. So it's not a lifestyle. It's not a mischaracterization of a law. I think duty to retreat is wise. It gives you a good guideline there. But again, duty to retreat has been weaponized by a lot of political entities on gun rights. Okay, and that's what we should be focusing on. It has nothing to do with people's fear between duty and retreat and stand your ground, because if you are in a self-defense scenario, a use of force event, you should not be considering law. You should be considering innocence, imminence, proportionality, avoidance, and reasonableness, and leave the legal fights in the courtroom. A legal battle is not good while you're looking at a gun. I just want to go over a couple of things before we go. This is getting too long, and I got to cut it off at some point. Don't confuse stand your ground with castle doctrine, all right? It shouldn't be tactical doctrine during a physical fight. It shouldn't happen. I will say that the Tennessee officer is pretty typical in what I have come to realize over the years, where they know police policy, but they do not know a civilian's responsibility about innocence, imminence, proportionality, avoidance, and reasonableness. The story about shooting an intruder on your porch, you better bring them in. I hear it all the time. Don't do it. If it's a good shoot, it's a good shoot. Again, a good shoot is a good shoot. You're not going to have to worry about it at all. The New Jersey officer specifically said in his scenario that the door was broken in twice. Okay? Again, for New Jersey, I'm not going to bring it in. If the door is broken and it's immediately there, you don't have a due to retreat. It's in its own statutes. I'm not going to go back there. This is getting too long. I think I've proven my point. The shooting a warning shot. Shooting a warning shot in in Florida is legal. Brandishing is legal. I think it's 776.012. And again, just because it's legal doesn't mean that you should do it. The guy points out very well that if you're not in immediate fear of great death or great bodily harm, why are you shooting a warning shot? That warning shot should just stop the threat so you're no longer in a deadly situation. He describes it well. The other thing is, if you're ever in one of these rooms and someone starts talking about a real incident, please, my God, tell him to shut up. That you don't want to be deposed by a civil lawyer or having to go to court because you told your story in a classroom. And this guy talking about his warning shot that he did, he talked himself into a felony. And it's on the internet. Okay? Please tell, if you're an instructor, don't take these questions. Only take hypothetical questions. Don't take real questions. All right? I hope this gives an overlay on what has perspired about the most common errors that instructors give about self-defense law. Officers are another bad source because they know about police policy, but they don't know what the civilian is required for. And lawyers don't know self-defense law either. All right, you need to take it with a grain of salt. It really is. Hopefully, I laid out a good case that I'm giving you the best information that is possible. Okay. When you're dealing with a castle doctrine, it could be a flowchart, just like New Jersey is. I'm not going to get into it because it's too long. All right. Win the physical fight. Learn innocence, eminence, proportionality, avoidance, and reasonableness. My name is Jeff. I hope this helped.